the claims that on humanitarian grounds they have paid 27 million naira to the workers as per paragraph 11 could not be true, as there is no proof to show that that 27 million has been paid. Uh, and the names produced without any of the representative of judgment creditor applicants being mentioned all all throughout the payment for over a year now. The judgment debtor respondent relied heavily on the provisions of Order 11 Rule 15 of the Judgment Enforcement Rules as well as Order 4 Rule 16 both to support this line of argument. However, it is the considered opinion and submissions of the judgment creditor applicants that no doubt a careful examination of the enroll order of this honorable court in NICN stroke CS stroke 13 stroke 2022, which is the consent judgment between the judgment debtor respondent and the judgment creditor applicant entered into on the 6th day of June 2024 has several clauses, one of which is clause 611, which is the contention here, amidst several others. According to counsel, that clause specifically provides for reconciliation of the first batch of land allocation. Counsel refers to Order 11 Rule 15 of the Judgment Enforcement Rules on by the counsel for the judgment debtor applicant and submitted that from the enroll order of this honorable court in suit number NICS-13 entered, particularly order number 6, which is the judgment debtors exhibit A, which the judgment creditor applicant equally relied on, there was a condition precedent, which condition has been conclusively fulfilled. According to counsel, for the judgment debtor respondent exhibit E, which is equally before the court, which exhibit is the extract of minute held on 27th day of October at the premises of the judgment debtor counsel Judgment Debtors Council office situated at number 78 for Abasi Street, Calabar, Cross River State, with the attendance of both parties in the suit, including their lawyers and other interested parties, especially a critical stakeholders in the aforesaid transaction, I. Patrick Odok Esquire, who happened to be the buyer purchaser of the allocated land in batch A land allocation. According to counsel, a careful reading and perusal of the aforesaid minutes will reveal that the tone and subject matter of the meeting as all the speakers had stressed on the need for the reconciliation of the judgment debtor respondent and the community. This this much can be seen from verbatim reproduction of the speeches made by the judgment debtors respondent counsel, Emmanuel Udo Esquire, Patrick Udo Esquire, who is the buyer purchaser, and including the judgment debtor respondent, general manager, general duties. It is further submitted that a reading of the aforesaid minutes of the meeting will show that on part of the judgment creditor applicant, document to show who had been paid, how much, and who was paid, completely paid, and those partly paid was demanded. Hence, this formed the basis for the meeting of 10th of October 2024, held at the premises of the judgment debtor respondent along Calabar Ecom Highway, Calabar. It was at this meeting that all the documents, i.e. judgment creditor applicants exhibit 001 A and B were presented to the House. Hence, the reconciliation of the first batch land allocation was successfully completed, thereby fulfilling a condition precedent as provided for under Order 11 of the Order 11 Rule 15 of the Judgment Enforcement Rules the 10th of October. Since the 10th of October, Council also argued that by their Exhibit 004, which is a letter to the buyer purchaser, it can be seen that payment was still ongoing as there has been a balance of 45 million which the buyer purchaser with the buyer that if paid but for the encroachment of the host community, everybody entitled would have been fully and completely paid. The isolated cases of the so-called complaints, which was referred to as being induced for the purposes of this matter, are but trivial compared to total number of 104 persons who are beneficiaries to the first batch transaction, and majority of whom have taken benefit. According to counsel, the judgment creditors, applicants wish to know the reason for the judgment debtor respondent producing extract, not producing extract of meeting, were producing the extract of meeting of 2nd October, but refusing to produce that of the 10th of October. Several months now, counsel refers to Section 167D of the Evidence Act and submitted that the judgment debtor respondent blatant refusal to produce extract of meeting of 10th of October 2024, which concluded the reconciliation much talk about is because they do not want this honorable court to know that reconciliation which is they have all the while used to use and predicated their non-compliance or enforcement of the judgment of this honorable court has long been concluded satisfactorily. Counsel further refers to the provisions of Section 1167C of the Evidence Act. Counsel submitted that notwithstanding judgment creditor applicants conspicuously pre, conspicuous presence and substantial contribution made as captured in the aforesaid minutes. Yet the judgment debtor responded in their paragraph 8 of the counter affidavit stated that the judgment creditor applicant refused to make themselves available for the reconciliation ordered in the consent judgment. For counsel, herein lies in the inherent falsehood around and perpetuated by judgment debtor respondent in order to mislead this honorable court into accepting their blatant failure and neglect to obey and comply with the directives of this honorable court as contained in the enrollment or in the enroll order of this judgment, which is the judgment debtor's respondents exhibit A. On this, counsel placed reliance on Section 167 of the Evidence Act and asked the court to presume existence of fact which it deems likely to have happened. Counsel submitted that the contradiction and blatant falsehood perpetuated by the judgment debtor in order to avoid the consequences of their blatant and intentional refusal to obey court order as contained in Exhibit A. Counsel queried how can a people who have voluntarily made themselves available in a meeting captured in Exhibit E all of a sudden be said to have been to have not to have presented themselves to reconcile as contained in the judgment debtor respondent paragraph 8 of the counter affidavit. It was submitted that, as can be seen from the provisions of Section 167 of the Evidence Act, there is no way people who presented themselves in a meeting cannot follow the process to conclusion. Knowing the consequences of it, it is the submission of judgment creditor applicant that the blatant refusal of the judgment debtor respondent that to produce the minutes of 2nd October and refuses to produce the minute of 10th October is but with the intention to mislead this court into believing them that there was no reconciliation by Section 167 of the Evidence Act. The common course of business events had been followed, as there is no way we will be in a meeting and will not follow to conclusion. By Section 167D, Y was minute of 10th October not produced before the court. Counsel asked the court to invoke the relevant provisions of Section 167 of the Evidence Act to hold that the refusal by the judgment debtor to produce the minute of meeting of 10th October would, if produced, be unfavorable to them, which is why they have withheld it. On the issue of complaints made by a selected induced members or persons who counsel said they knew it was at the prompting of the judgment debtor respondent. Counsel committed that the failure by the judgment debtor respondent to reconcile with the host community so that title to the allocated land would have been handed over to the buyer purchaser, wherein purchaser would have paid the balance of 45 million naira still in his hands, and that this balance would have been used to offset and fully pay off all those who have not been fully paid, as can be seen in Exhibit 004. Therefore, judgment debtor respondent Exhibit C1, C2, C3, C4 respectively are not in issue, as the judgment debtor is quite aware of the fact that this amount of money is still in the hands of the buyer purchaser. Hence, this complaint is without any basis, but a means of by the judgment debtor respondent to find an excuse and a way out for non-compliance with the judgment of this court. On the claim for payment of 27 million in paragraph 11 and 15 of the counter affidavit, counsel contended it was false and misleading, as paragraph 8 of further and better affidavit shows that assuming but not conceding the fact that the said payment, the total money so far paid is 14,560,349 naira. It was also submission of counsel that from the totality of all that have been said, the clear provisions of Section 44 of the Section 44 of the Sheriff and Civil Process Act have been fulfilled, being that the judgment debtor has blatantly refused, neglected to either obey or to comply with the judgment of this court. Counsel asked the court to invoke the provisions of Section 44 of the above cited law and grant leave to the judgment creditor applicants to issue writ of execution on immovable properties of the judgment debtor. See Bayero versus Federal Mortgage Bank of Nigeria PLC. See also Lido Presidential Hotel Limited versus Bond. In concluding his submission, counsel asked the court to look at the plight and suffering of the laborers of this organization, majority of whom have died on account of non-payment of their meager salary, allowances, and other legitimate entitlement for over 10 years now, with no hope of whatsoever, except if this court is minded to bring hope to these people as left alone to their employers. They are determined that until the last person dies, no kobo shall be given to anybody, as can be seen by the willful non-compliance of the order. Counsel asked the court to grant this application by granting leave for the issuance of the writ of execution on immovable properties of the judgment debtor respondent for the interest of justice and enjoyment of the fruit of labor. On the 11th day of November 2025, counsel for the judgment creditor applicant filed a list of 5 cases as additional authorities. I have examined the said authorities but I'm able to find them to be relevant to the issues under consideration in this application. Court decision. I have considered the motion on notice, the affidavit in support, the counter affidavit, the exhibit attached to the affidavit of the parties. I have equally carefully and painstakingly considered the, the additional the five additional cases, the written address, the written address and oral submissions of counsel for the parties. The facts made the facts that made the judgment creditors applicant to file this application and those facts put forward by the judgment debtors in opposition to the application by the judgment debtor respondent have herein before been have herein before in the earlier part of this ruling been stated clearly. There is no need to repeat them here. It is suffice to state that the judgment of the court delivered on 6th of June 2024, which is the subject matter of this application, was a consent judgment upon the amicable settlement of the dispute by the parties themselves after a series of negotiations. The law is right that where parties settle or reach a compromise during pendency of a proceeding, the settlement or compromise arrived upon constitute a new legal regime and an independent agreement always the parties made for good consideration and may not even necessarily be for sufficient consideration. This is because the terms of settlement put to an end the pending proceeding and that the relief becomes spent. It operates in an estoppel, stopping the parties from taking further steps contrary to the agreed terms. The agreed terms becomes the regulating instrument of the parties' conduct and relationship by virtue of the agreed bound by the terms of agreement. However, the very like every other judgment of the court, it is enforceable in the event of default. A consent judgment, as established in the case of Wolokim versus Sokoma, 1974, it is a judgment entered by the court with the agreement of the parties. If with the agreement of the parties, it derives its force from the agreement of the parties and is binding on any judgment given by the court after a full trial. The Supreme Court in the case of Race Auto Supply Company Limited and others outlined the requirements for a valid consent judgment, emphasizing that it must be a product of genuine agreement between the parties. Once entered, it becomes the judgment of the court and is enforceable like any other judgment. The terms of settlement, when were reduced into writing and made a judgment of the court crystallized into a consent judgment as seen in Virginia and others versus Wordu and another, and Palaki versus Pagbuyoro on enforcement of judgments through the attachment of immovable properties. Like in this case, the Sheriff and Civil Process Act has made ample provisions to government procedure for consideration of such application. Section 44 of the Sheriff and Civil Process Act Section 44 of the Sheriff and Civil Process Act laid down the general principles for attaching immovable property in that this method or procedure of enforcement is resorted to when the movable property of the judgment debtor are insufficient or cannot be found after diligent search. This is the fundamental procedural safeguard to ensure debtors are not unduly deprived of their primary asset without which exhausting other means. The judgment creditors in this case conceives that the judgment debtor is in default of the same settlement. That's why they brought this application pursuant to section 44 of the Sheriff and Civil Process Act to enforce the terms of the consent judgment by attachment of the immovable property of the judgment debtor respondent. According to the judgment creditor applicant, the consent judgment entered by this court following filing of the terms of settlement by the parties has not been obeyed by the judgment debtor respondent, as there is no refusal in the share as there is a refusal to adhere to the timeline contained in the consent judgment for doing certain activities or contained in order 3 and 4 of the consent judgment, in that by the consent judgment payment of the sum of 200 million naira by land swap to the individual judgment creditors workers ought to have commenced since July 2024 as per order number 3 in the said consent judgment, but till date no piece nor portion of land has been given to any person in lieu of the aforesaid judgment. There is also the alleged non-compliance with the order 4. It is clear to me that the grievance of the judgment creditor applicant is on alleged non-compliance by the judgment debtor respondent with order 3, 4, and 5 of the consent judgment. For the purpose of appreciation, the 3 orders are hereby reproduced. I have reproduced them in the body of the judgment, so I will keep reading them. The judgment creditor's application pursuant to section 44 of the Sheriff and Civil Process Act was promised on the ground that upon reasonable diligence, no movable property of the judgment debtor can be found in Cross River State or elsewhere. It is apparent the provisions of section 44 of the Sheriff and Civil Process Act places a burden on the judgment creditors applicant to demonstrate that such diligence was indeed exercised. The judgment debtor respondent on its part maintained that enforcement of the consent judgment was conditional upon reconciliation of the first batch or land swap program of the judgment debtor between both parties. The consent judgment cannot be enforced or implemented until reconciliation is done. The judgment debtor responding further about that, despite the refusal of the judgment creditor applicants to reconcile, the judgment debtor respondent on humanitarian ground has paid the workers from the 6th day of June 6th day of June was consent was delivered. They have paid the sum of more than 27 million naira as per exhibits H1 and H2. The judgment debtor respondent has also stated that in paragraph 14 of the counter affidavit that the judgment creditor applicant have not shown any way how much diligence searches were made. In response to the judgment debtor's abatement in their counter affidavit, the judgment creditor in their further and better affidavit insisted that the condition precedent has been fulfilled from the minutes of the 10th day of October 2024. However, the judgment creditors in their response have insisted that the condition precedent has been fulfilled from the minutes of meeting of 2nd day of October 2024, which is 24, which is Exhibit E, coupled with another meeting of 10th day of October 2024. In all, representatives of the parties were present, and at the meeting, all documents required from the defendant from the judgment requested by the judgment debtor respondent were presented, and all contending issues in the first batch of land swap program were amicably resolved in 2 meetings that were held from the decision of the House that the judgment debtor respondent shall endeavor to reconcile with the host community as per the issue of title. It is clear to me from the judgment debtor's opposition to the application before the court raises two critical points, i.e., non-fulfillment of condition precedent and the consent judgment, and the judgment creditor's failure to state specific steps taken for the diligence search of the movable property. Let me make it clear that this court is bound to respect and give full effect to the sanctity of the intentions of the contracting parties once it is satisfied that there is no fraud or misrepresentation imbued in the terms. On the issue of consent judgment of 6th day of June 2024, so the subject matter of this application can equally be imposed upon fulfillment of condition precedent contained in Order 11 of the consent judgment. The parties are not at ad idem on the issue of requirement for reconciliation of issues affecting first batch of plot allocation junior workers. The judgment debtor respondent insisted that there was no reconciliation, therefore the terms of consent judgment cannot be imposed by the court through attachment of immovable properties of the judgment debtor respondent. As the application for enforcement is premature, it has to await reconciliation. The judgment creditors applicants on their part are of the view that reconciliation had been concluded, all issues settled at the meeting of 22nd day of October 2024 and that of 10th of October 2026. 2024 attached by the parties. An appraisal of the affidavit evidence before the court filed by the parties evidently shows that there are still some gray areas respecting issue of first batch of allocation, land swap allocation. This is evident from Exhibit E, minutes of meeting of second day of October 2024, where there is consensus, that the judgment debtor need to reconcile with the host community. The judgment debtor has tendered Exhibit D lease agreement as evidence of the as evidence of title. Notwithstanding Exhibit D, there are still issues or as borne out by Exhibit E. In the circumstances, I have no choice than to come to the conclusion that no reconciliation had been completed between the parties more particularly when the purported minutes of meeting of 10th of October had not been brought or produced before the court for the court inspection. The judgment creditors applicants have put the judgment debtor on notice to produce the said minutes, but it failed to do so. The service of a notice or giving notice to produce document on the adverse party pursuant to Section 91 of the Evidence Act does not compel the party served to produce or make available the said document to in compliance with the notice. Rather, it entitles the party serving the notice to adduce secondary evidence of the document in question. In this case, the judgment creditors applicants not only pleaded minutes of the meeting of 10th of October 2024, but gave the judgment debtor respondent notice to produce the said minutes of meeting. The consequences of serving notice to produce is not the invocation of the provisions of Section 167 of the Evidence Act as amended. If the other party whom is not the invocation of provision of Section 167 of the Evidence Act as amended. If the other party whom notice to produce is served failed to produce the document, the remedy of the party serving the notice is to adduce secondary evidence of the content of the document or documents itself. In other words, failure of the party served with the notice to produce a document within in the instant case, Section 97(1)(a), read jointly with Section 98 of the Evidence Act, permits the appellant permits the judgment creditors permit the judgment creditors applicant to produce secondary evidence of the document which they serve the judgment debtor notice to produce or refuse to produce, the remedy is to adduce secondary evidence. In other words, failure of the party served with the notice to produce a document entitles the party serving the notice to lead or adduce secondary evidence of that document. In the instant case, Section 91, Section 1, read jointly with Section 98 of the Evidence Act, permit the judgment creditor in this case to adduce secondary evidence. Permit the judgment creditors to adduce secondary evidence of the minutes of the meeting of 10th of October 2024. See the case of Buhari versus Obasanjo. See also Eweje versus OM Oil Industries Limited. See also the case of Awuse versus Odili. A law giving of notice to produce is not excuse for the party giving the notice not to produce secondary evidence of the document if the party he puts on notice refuse to comply. Therefore, Section 167D of the Evidence Act being invoked by the judgment creditor applicants cannot be of any assistance to the judgment creditor applicant. As the said provisions of the Evidence Act does not apply in this situation, the judgment creditors applicant who are relying on the documents to produce reconciliation are the ones that are in law. The judgment credit to applicants who are relying on the document to produce are to produce secondary evidence if the party served, that is the judgment debtor, refuse to comply. However, However, the question now to be resolved is, can non-reconciliation of first batch of land allocation be an excuse for not obeying the terms of the consent judgment by the judgment debtor? It is to be noted that the consent judgment subject matter of this application has several orders, some of which their compliance cannot be based or cannot be based on issue of reconciliation, i.e. best batch of land swap allocation. It is my firm view that the issue of reconciliation is in respect of first batch of land swap allocation to junior staff. The reconciliation does not affect the other orders of the consent judgment, like order 4, which is payment of the sum of 92 million naira. Furthermore, where an order of or judgment will work injustice on one of the parties, this court, apart from being court of law, is also a court of equity. Therefore, it has the unfettered power to set aside that particular order or judgment that will occasion injustice on any of the parties. See the case of UBA versus Ajileye. See also Okapo versus AG Anambra State. See also Covalent Oil and Gas Limited versus Ecobank Nigeria Limited. It is my humble view that Order 11 of the consent judgment, which counsel for the judgment debtor has been hammering or relying heavily to deny judgment creditors applicant right to reap their fruit of the judgment, will work injustice to the judgment creditors, more particularly when considering that the judgment borders on unpaid gratuity and other entitlement. To deny In my view, the Order 11 was aimed at denying the judgment creditor to reap the fruit of their judgment, and this denial will deny them of their livelihood, which by extension will amount to also breach of their fundamental right. Terminal benefit is sacrosanct. That part, no party will be entitled to deny. No party will be entitled to deny the person entitled to his terminal benefit. It is worrisome that the condition precedent in the consent judgment order 11 will work injustice against the judgment creditors applicant. It will impede easy realization of the consent judgment, as we have seen in the drama that has unfolded. While consent judgments are generally sacrosanct, courts retain the inherent power to prevent such kind of to prevent any order that will occasion injustice to be operated. The case of Aerobel Nigeria Limited versus NDIC acknowledges instances where consent judgment may be considered unenforceable if a condition precedent, though agreed upon, effectively renders the judgment nugatory or impossible to be enforced, especially the entitlement like gratuity, which are often considered fundamental rights of employees. A court may incline to intervene, like in this case where the order, which is a condition precedent, will work injustice and deprive the judgment creditors of reaping the fruit of their judgment. Therefore, if the condition precedent, i.e., the reconciliation, makes the judgment particularly unenforceable, it could be argued that it defeats the very purpose of the judgment and lead to an absurd outcome, which no court of justice will countenance. In view of the foregoing, Order 11 of the consent judgment meant to deny judgment creditors their entitlement under the consent judgment must be struck out, and I hereby strike it out, as it will work injustice judgment against the judgment creditors and to prevent the realization of the consent judgment itself. The second critical issue for resolution is respecting entitlement or otherwise of the judgment creditor applicant to grant of order of execution as on immovable properties of the judgment debtor respondent. The question to be answered is, has the judgment creditor applicant by the affidavit evidence, in this case, established entitlement to grant of order being sought pursuant to Section 44 of the Sheriff and Civil Process Act? I shall start by reproducing the provisions of Section 44 of the Sheriff and Civil Process Act, under which the judgment creditors applicant are seeking for the reliefs in the motion paper before the court. Section 44 of the Sheriff and Civil Process Act read as follows. If sufficient movable property of the judgment debtor can be found in the Federal Capital Territory, Abuja, or the state, as the case may be, to satisfy the judgment and cost of execution, the and cost of execution. Execution shall not issue against the immovable property. But if movable property of the judgment debtor can with reasonable diligence be found, or if such property is insufficient to satisfy the judgment and the cost of execution, and the judgment debtor is the owner of the immovable property, the judgment creditor may apply to the court for a writ of execution against the immovable property of the judgment debtor. An execution may issue from the court against the immovable property of the judgment debtor in accordance with the provisions of this act and any rule made thereunder. The above provisions of the law on levying executions levying execution on immovable property is very clear and unambiguous. The section has been considered severally by the appellate courts in numerous and uncountable decisions. The section has laid down the matters to be considered by the court in deciding whether or not to grant order for execution carried out. The section has laid down matters to be considered by the court in deciding whether or not to grant the order of execution on the immobile property, like in the present application. See the case of Badamosi versus UBA. From the content of the provisions of order of section 44 of the Sheriff and Civil Process Act, it is clear to me that the execution against immovable property is considered exceptional remedy. Therefore, for court is required strictly to comply with the procedural requirement before granting leave to levy execution of immovable property and getting. The guiding principle is that movable property should first and foremost be exhausted before resorting to immovable property. For an affidavit in support of application to levy execution against immovable property must contain necessary material facts showing effort made to execute on movable property of the judgment debtor, but without success. Not just mere assertion or conclusion that no movable property can be found with reasonable diligence without stating or particularizing all the effort made in order to locate the movable properties of the judgment debtor. The applicant must demonstrate what steps were actually taken to locate the movable properties of the judgment debtor without success. This may include attempt to serve writ of execution of movable property without success, inquiries made on the judgment debtor's known addresses or place of business, search conducted by bailiff on the land. This means the law requires the judgment creditor applicant to provide concrete evidence of all effort made but to no avail. The requirement for a diligent search, as provided for in Section 44 of the Sheriff and Civil Process Act, is not merely a formality. It is a substantive condition that must be met before granting order or to attach immovable property of the judgment debtor respondent. The judgment debtor's argument that the judgment creditor has not stated the step taken for the diligent search is a valid challenge to the application. This court expects the judgment creditor's applicants to provide concrete evidence or a detailed account on the effort made to locate movable properties of the judgment. This court expects judgment creditor applicant to provide concrete evidence or details account of effort made to locate movable assets of the judgment debtor. The reason being that the law places the onus squarely on the shoulders of the judgment creditors. Without such details, this court may find that the condition for proceeding against immovable property has not been adequately established. For clarity, in the case at hand, the judgment creditors applicant in their affidavit stated that for reasonable diligence, no movable property of the judgment debtor can be found in Cross River State or elsewhere. The applicants did not give details of the reasonable diligence conducted when this which did not result in locating the movable property of the judgment debtor on Cross River State or elsewhere. They also did not state the elsewhere mentioned by them where they purportedly conducted the due diligence. The failure by the judgment creditor applicant to state the effort made by them to locate immovable property to locate movable properties of the judgment debtor, but to no avail further to their case. In the case of Bello versus Akambe versus Mahmuda Alao, the Supreme Court stated that where a party is to establish a fact with reasonable diligence, he must show the actual step taken and cannot rely on mere assertions. Similarly, in Daudu, Adda versus Sahi Ubandawaki, the apex court stated that a party cannot succeed on scanty or vague assertion without certainty. This court cannot grant execution against immovable property where the affidavit merely stated a conclusion which without particularizing the diligence effort made. In this case, this court cannot lend its ears to the judgment creditor's applicant without specific details of the searches conducted, if any, where and when such searches took place or conducted, what results were obtained, or the belief returns, etc., confirming effort made but to no avail on the properties to locate the properties of the judgment creditor, creditors. From all I have been saying above, the judgment creditors have woefully failed to prove entitlement to grant of this application due to non-particularization of the effort made in the due diligence to locate, and also for failure to inform the court that, and for failure to also categorize to catalog and list the effort made to locate the said movable to locate the movable properties of the judgment debtor. In any event, execution of immovable property is a last resort. The party wishing to to utilize the said mode of execution must also disclose to the court the other mode of execution he has tried but could not impose the judgment. That is when the court will have will adequately grant the said application. Before ending this application, before ending this ruling, let me say that the affidavit evidence laid before the court by the parties have clearly exposed how helpless litigants are exploited by powerful persons due to the level of their literacy. I am sure if the majority of the litigants in this case are well educated, they would have resisted exploitation and shoddy treatment they have they have been subjected to in the pursuit of their right. Let me remind counsel in this case that as ministers in the temple of justice, they are expected to side with the cause of justice and not serve as a vehicle through which the marginalized members of the society are subjected to more hardship. Therefore, I plead with all concerned in this case to tarry a bit to ensure that the judgment creditors in this case are assisted in all ways possible to reap the fruits of their labor without further delay. I pray something is done to end the cry of the judgment creditors applicant to the high heaven. From all I have been saying above, the judgment creditors applicants have woefully failed to prove or to satisfy the requirement of the law as contained in Section 44 of the Sheriff and Civil Process Act for the grant of an order for the grant of leave for them to levy execution on immovable properties of the judgment debtor as to judgment debtor as the use of execution through attachment of immovable property can only be granted when all ways of execution could not be resorted to. The application failed, same is hereby refused. I make no order as to cost. Parties to bear their respective cost. Ruling is entered accordingly.
My Lord, with respect, we thank you for the judgment, and we promise, having heard the advice of your Lordship, we shall try as much as possible to advise our client to see what they can do based on the consent judgment we entered. Thank you, sir.
Thank you. Okay. Thank you. Mr. Obiji, I can't hear you. You have muted yourself. You have to unmute yourself. You have muted yourself. You have to unmute yourself. You have not unmuted yourself. You have to unmute. Click on the speaker. Click on the speaker. You have to unmute yourself for you to be heard. Just touch the screen. You will see speaker coming out. You click on it. Your microphone will open. Yes. You can now talk.
My Lord, most respectfully, we are thanking for the end of the day. We are most guided. But my Lord, like we have already said, it is not over. We will continue to ensure that the harmless government creditors applicant will take the fruit of the fundamental. Thank you.
You are welcome. Thank you very much, Council, for all your cooperations. I think we have only this ruling today, so we have come to the end of our today. Thank you very much.
Thank you, sir. We are grateful, sir.
You are welcome.
Thank you. Okay, now finish. Just
Okay.
thank you.